The inheritance clause. A Cincinnati courtroom, 10 minutes before 9 in the morning. Daniel Whitfield sits at the plaintiff's table with his hands pressed flat against a manila folder, like he's trying to keep it from floating away. Across the aisle, his older brother Marcus adjusts his cufflinks and doesn't look at him. Behind them, the gallery is filling with people who used to be family friends and are now just spectators. The bailiff calls the room to order. All rise. The Honorable Judge Patricia Reyes presiding. Daniel doesn't rise right away. For 3 seconds, he just stares at the folder in front of him, the one that could either save what's left of his family or destroy it completely. Then he stands. Because in the next hour, a judge is going to decide whether the man who raised him, a furniture maker who built an empire out of a one-room workshop, actually meant for his younger son to be erased from his own legacy, or whether Marcus Whitfield forged the ending of that story before anyone else could read it. This is where it begins. Not with the funeral, not with the will. With the moment Daniel Whitfield finally stopped being quiet. Part 1. The Workshop. 6 months earlier, the Whitfield family home in Blue Ash, Ohio, still smelled like sawdust, even though Robert Whitfield hadn't touched a lathe in over a year. Daniel found his father in the garage workshop at 2 in the morning, running his palm along the edge of an unfinished rocking chair. Robert's hands shook now. Parkinson's had taken the steadiness that once built half the furniture in 3 states. You should be asleep, Dad. I should be a lot of things, Robert said, not turning around. Doesn't mean I am. Daniel picked up a chisel from the bench, turned it over in his hands. He'd grown up in this garage, sanding table legs on Saturday mornings, while Marcus, 4 years older, sat in their father's office learning about invoices and margins and the business side of things, as their dad used to say. Robert Whitfield had built Whitfield & Sons Furniture Company from a single workbench into a regional brand with 3 showrooms and a factory that employed 200 people. And for 30 years, everyone in Blue Ash had assumed the Sons in the name meant both of them. I need to tell you something, Robert said. His voice had gone thin lately, like paper left out in the rain. About the will. Daniel set the chisel down. Dad, we don't have to do this right now. Yes, we do. Because I know how your brother operates, and I know how he'll try to read it once I'm gone. Robert finally turned, and his eyes were sharper than his shaking hands. I split it evenly, Daniel. The house, the company shares, the savings, 50-50. But I added something else. A clause your brother doesn't know about. What kind of clause? Robert almost smiled. The kind that protects the people who actually earned it. 3 weeks later, Robert Whitfield died in his sleep. And within 9 days, Marcus Whitfield had already changed the locks on the factory. Part 2. The reading. The reading of the will took place in a downtown office on the 14th floor, in a conference room with a view of the Ohio River that nobody bothered to look at. Daniel sat beside his mother, Eleanor, who held a folded church bulletin from the funeral like it was the only solid thing left in the world. Eleanor's memory had been slipping for over a year. Some days she called Daniel by his father's name, but today, in this room, she seemed present, watching, waiting, like she already knew something was wrong. The family attorney, a soft-spoken man named Arthur Kessler, cleared his throat and opened a folder. This is the last will and testament of Robert James Whitfield, executed and notarized on March the 4th of this year. Marcus leaned back in his chair, already comfortable, already certain. Kessler read through the preliminary language sound mind, revoking prior wills, the usual formalities. Then he reached the distribution section, and his voice changed. To my wife, Eleanor Whitfield, I leave the family home at 214 Sycamore Lane, along with a trust to be managed for her continued care. Eleanor's hand tightened around Daniel's. To my sons, Marcus Robert Whitfield and Daniel James Whitfield, I leave equal shares, 50% each, of Whitfield and Sons Furniture Company, its assets, accounts, and all associated intellectual property. Marcus exhaled, satisfied, like a man confirming what he already believed, but Kessler wasn't finished. There is an addendum, he said, attached and notarized separately, dated 1 week before Robert's passing. Marcus sat up. I don't have a copy of that addendum in my file, Kessler admitted. Robert instructed me that it would be delivered by a third party under his specific instructions 30 days after his death. The room went silent. Marcus's jaw tightened. That's not standard procedure, he said. No, Kessler agreed. It isn't. But your father was very specific. He said, and I'm quoting him directly from our last meeting, I don't want anyone rewriting my intentions before the ink dries. Daniel felt something shift in his chest. His father had known. Somehow, his father had known exactly what was coming. He just didn't know yet how far his brother would go. Part 3. The Takeover. 9 days after the funeral, Daniel drove to the factory on Route 42 to check on the morning shift, the way he'd done every week for the past 6 years, while quietly managing operations his father trusted him with. His keycard didn't work. He stood at the employee entrance, badge in hand, while a security guard he didn't recognize watched him through the glass door. I'm sorry, Mr. Whitfield, the guard said, not unkindly. Your access was revoked yesterday. Corporate directive. Corporate directive from who? Marcus Whitfield. He's listed as acting CEO. Daniel called Marcus 4 times that day. Marcus answered on the 5th. You changed my access, Daniel said, without talking to me, without a board vote, without anything. There is no board, Daniel. There's me and there's you, and until the estate clears probate, someone has to keep this company running. I'm the oldest. I've got the MBA. I've got the relationships with our suppliers. You've got a business degree from a state school, and 6 years of watching from the sidelines. I wasn't watching from the sidelines. I ran production. I ran half of this company while you were in Chicago chasing commercial real estate deals. And now I'm back, Marcus said, and I'm doing what needs to be done. Don't make this ugly. The line went dead. That night, Daniel sat at his kitchen table with his laptop open, staring at the company's shared financial drive. Files he used to have full access to now returned an error message. Access denied, permission required. He wasn't just locked out of a building. He was being erased. Part 4. The First Hearing. 29 days after Robert Whitfield's death, a courier arrived at Arthur Kessler's office with a sealed envelope, exactly as instructed 30 days out, not a moment sooner. Kessler set it in his safe unopened and called Daniel that same afternoon, his voice careful, almost apologetic, like a man delivering news he didn't yet understand himself. It's here, Kessler said. The addendum. I'll open it tomorrow per your father's instructions, and I'll call both you and Marcus the moment I do. Daniel barely slept that night. He kept thinking about the workshop, about his father's hands shaking around a chisel, about a sentence that had lodged itself in his chest for weeks. The kind that protects the people who actually earned it. He didn't know what was in that envelope, but some part of him, the part that still remembered being 12 years old and watching his father lock the shop at night, believed his father had left him something more than money. He believed his father had left him proof. Marcus, it turned out, wasn't willing to wait and find out. 2 days before Kessler was scheduled to open the envelope, Marcus's attorney filed an emergency petition in Hamilton County Probate Court, asking the judge to grant Marcus sole temporary control of the company's operating accounts, citing the need for continuity of business and concerns about Daniel's capacity to manage complex financial operations. The filing landed in Daniel's inbox at 6:14 in the morning, before he'd even had coffee, timed to be heard before the addendum could ever reach the record. Daniel called Grace Alvarez before he'd finished reading the second page. "He's trying to beat the clock," Daniel said. "Whatever's in that envelope, he wants a judge to lock in his control before anyone reads it." Grace, a probate attorney with a reputation for being quiet in negotiation and merciless in a courtroom, read the petition twice before looking up at him. "He's trying to move fast," she said. "Freeze the accounts under his name before the addendum even gets read into the record. If he controls the money before the terms of the will are settled, he controls the leverage." Can he do that? He's trying to. That's why we're going to be in front of a judge by Thursday. The Hamilton County courtroom on Thursday morning was smaller than Daniel expected. Wood paneling, uncomfortable benches, the low hum of an old air conditioning unit. Judge Patricia Reyes presided with the calm efficiency of someone who had seen 1,000 family disputes dressed up as legal arguments. Marcus's attorney, a sharp, silver-haired litigator named Preston Cole, stood first. "Your Honor, my client has managed operational continuity at Whitfield & Sons for the past 3 weeks without incident. Revenue is stable. Payroll has been met. We are simply asking the court to formalize what is already functioning well, pending full resolution of the estate." Judge Reyes turned to Grace. "Ms. Alvarez?" Grace stood, calm and unhurried. "Your Honor, what Mr. Cole is calling stability is actually a unilateral takeover. My client, Daniel Whitfield, was locked out of his own workplace 9 days after his father's funeral, without notice, without a vote, without any legal authority. And there is an addendum to Robert Whitfield's will, notarized 1 week before his death, that has not yet been read into evidence. We're asking the court to preserve the status quo joint access, joint oversight, until that addendum is properly reviewed." Preston Cole shot back immediately. "Your Honor, this so-called addendum has never been seen by this court, by the executor's original file, or by anyone besides a mysterious third party my opposing counsel has yet to identify. I'd ask the court not to delay a functioning business over a document that may not even exist." Judge Reyes studied both attorneys for a long moment. "Mr. Kessler," she said, addressing the family attorney seated in the gallery, "you were named executor. Do you have this addendum in your possession as of today?" Kessler stood. "I received it this morning, Your Honor. Per Mr. Whitfield's explicit instructions, it was couriered to me exactly 30 days after his passing from a safety deposit box held under a separate name." A ripple went through the gallery. Marcus's face didn't move, but his hand, resting on the table, curled slowly into a fist. "Then I want to see it," Judge Reyes said, "in chambers, before I rule on anything." Part 5. The addendum. In chambers, Judge Reyes read the single-typed page twice before setting it down. "Ms. Alvarez, Mr. Cole, I'm going to read this into the record when we reconvene, because I think both your clients need to hear it exactly as written, not summarized." 15 minutes. Back in the courtroom, the gallery had grown. Word had spread through the extended family cousins, an aunt from Dayton, 2 of Robert's old business partners, that something unusual was happening in probate court. 4. Judge Reyes adjusted her glasses. "This is Exhibit C, an addendum to the last will and testament of Robert James Whitfield, notarized on March the 28th, 1 week prior to his death, by Notary Public Diane Ferris and witnessed by Walter Higgins. Daniel's breath caught. Walter Higgins. His father's oldest friend and former business partner, a man Daniel hadn't seen since the funeral, when he'd stood quietly in the back and left before the reception even started. Judge Reyes continued reading. I, Robert James Whitfield, being of sound mind, add the following condition to my prior will. In the event that either of my sons attempts to seize unilateral control of Whitfield and Sons Furniture Company, its accounts, or its assets, prior to the equal 50-50 distribution being formally executed, and both sons being given equal opportunity to manage the transition, that son shall forfeit his 50% share of the company entirely, and it shall pass in full to his brother. This clause exists because I know my sons. I love them both. But I built this company on fairness, and I will not let it be inherited through force. The courtroom went dead silent. Marcus's attorney was the first to speak. Your Honor, this document is unverified. My client had no knowledge of any such clause. That may be true, Judge Reyes said evenly, which is precisely why the court is going to take this seriously. Mr. Whitfield, she looked at Marcus directly. You locked your brother out of the company 9 days after your father's funeral, before any formal distribution, before any agreement. Is that correct? Marcus's voice, when it came, had lost its earlier confidence. I was protecting the business. That may be your intention, but your father seems to have anticipated exactly this situation and built a legal consequence around it. Judge Reyes closed the folder. I am not making a final ruling today. This addendum needs to be authenticated, the notary, the witness, the timeline, before I can apply its terms. But as of this moment, I am ordering joint operational control of Whitfield and Sons restored immediately, and I'm scheduling a full evidentiary hearing in 3 weeks to determine the addendum's validity and enforceability. She looked at both brothers, her expression softening only slightly. I'd also encourage both of you to remember that your father wrote this because he loved you. Don't turn his last wish into a war. Marcus said nothing, but as the gallery emptied, Daniel caught his brother staring at him with an expression he hadn't seen since they were teenagers. Not anger exactly. Something closer to fear. Part 6. The Witness. Grace Alvarez tracked down Walter Higgins 2 days later at a diner off Montgomery Road, the kind of place with cracked vinyl booths and coffee that never stopped coming. Walter was 71, broad-shouldered, with hands that still looked like they belonged to a man who used to build furniture for a living, because they did. He and Robert had started the company together in a rented garage in 1988, before Walter sold his shares back in 2005 to start a smaller custom woodworking operation of his own. I wondered when someone would come find me, Walter said, before Grace had even sat down. You witnessed the addendum, Grace said. I did. Bob called me 2 weeks before he passed, said he needed someone he trusted completely, someone with no financial stake in the company anymore, to witness something important. I met him and the notary at her office on a Tuesday afternoon. He read every word out loud before he signed it. Made sure I understood exactly what it meant. Why the secrecy? Why not just tell his sons directly? Walter's jaw tightened. Because Bob had already seen it happening. 6 months before he died, Marcus tried to get him to sign over majority control early, said it would simplify the transition, and help with some tax strategy Marcus had cooked up with an estate planner Bob never approved of. Bob refused, but it scared him. He told me, Walter, that boy is going to try to take it the second I close my eyes. I need something that stops him cold, and I need it hidden until it's too late for him to argue his way around it. Grace leaned forward. Would you testify to that? In court? Under oath? Walter's eyes, tired but steady, met hers. Bob was my best friend for 35 years. I'll say it as many times as they need to hear it. Daniel, sitting quietly beside Grace through the whole conversation, finally spoke. Did he ever say anything about me? About why he trusted me to run things? Walter's expression softened. He said you were the only one who ever asked him how the workers were doing before you asked how the numbers looked. He said that mattered more to him than any MBA ever could. Daniel had to look away for a moment, out the diner window, to keep himself from breaking down in front of a man he'd just met. Part 7. The counterattack. 10 days before the evidentiary hearing, Marcus changed his strategy. Preston Cole filed a new motion, not challenging the addendum's authenticity directly, but arguing something far more dangerous, that Robert Whitfield had lacked the mental capacity to execute a valid addendum in his final weeks, given his advancing Parkinson's diagnosis and documented cognitive changes noted by his physician. Grace read the motion at her desk with her jaw tight. He's trying to have the whole thing thrown out on capacity grounds, she told Daniel. If he can convince the judge your father wasn't of sound mind when he signed that addendum, none of it matters, the clause, the forfeiture, any of it. My father was sharp until the day he died, Daniel said. His hands shook. His mind didn't. I believe you, but belief isn't evidence. We need medical records, and we need someone who saw him regularly in his final month to testify to his mental state. That someone turned out to be Dr. Priya Nadkarni, Robert's neurologist for the past 4 years. When Grace subpoenaed her records and requested her testimony, Dr. Nadkarni didn't hesitate. I saw Robert Whitfield 11 days before he passed, she told Grace over the phone. His physical decline was significant. His cognition was not. I administered a standard mental status exam at that visit, specifically because he asked me to document it. His words were, I want this on paper in case anyone tries to say I didn't know what I was doing. Grace nearly dropped the phone. He asked you to document it? He did. I found it unusual at the time. Now it makes a great deal more sense. Robert Whitfield, it seemed, had been building his defense from beyond the grave, anticipating every move his older son might make, 3 steps ahead, the way he used to plan out a piece of furniture before he ever touched the wood. That night, Daniel drove out to Sycamore Lane and sat with his mother on the back porch, the one his father had rebuilt with his own hands the summer Daniel turned 16. Eleanor didn't fully understand what a capacity motion was, but she understood the shape of what Marcus was trying to do. He's saying your father didn't know his own mind, Daniel told her quietly, in the last weeks. That's the argument. Eleanor was still for a long moment, her fingers working the edge of her cardigan. Then she said, with a clarity that startled him, your father knew exactly what he was doing the whole time he was dying. He was more himself in those last weeks than he'd been in years, like he could finally see all of it clearly, all at once. She reached over and took Daniel's hand. Don't let your brother turn your father's last, clearest days into something to be ashamed of. Daniel held on to that sentence all the way into the courtroom 3 days later. Part 8. The hearing begins. The evidentiary hearing opened on a grey Tuesday morning in a courtroom packed tighter than before. Eleanor Whitfield sat in the front row between Daniel and her sister, wearing her husband's old cardigan, the one that still smelled faintly of cedar and sawdust. Judge Reyes called the proceedings to order. Preston Cole opened for Marcus, methodical and composed. Your Honour, this case is not about fairness. It's about whether a document, drafted in secret and hidden for 30 days, executed by a dying man under significant physical and possibly cognitive strain, should override decades of clear intent that Whitfield and Sons would be run by capable leadership. We intend to show that Robert Whitfield's condition compromised his judgment in his final weeks, and that this addendum does not reflect his true wishes. Grace stood next, unhurried. Your Honor, we intend to show the opposite, that Robert Whitfield was of entirely sound mind, that he anticipated exactly this dispute, and that he built legal safeguards specifically because he understood his older son's character better than anyone in this room. This is not a story about a confused old man. It's a story about a father who saw the future clearly and tried to protect it. Dr. Nadkarni took the stand first. Under Grace's questioning, she walked the court through Robert's final cognitive assessment, sentence by sentence, his memory recall, his orientation, his reasoning ability, all within normal range for his age, all documented 11 days before his death, at his own explicit request. Preston Cole rose for cross-examination. Dr. Nadkarni, isn't it true that Parkinson's disease is frequently associated with cognitive decline, including in its later stages? It can be, yes. It was not the case for Robert. But you can't rule out fluctuations, good days and bad days. I can't rule out fluctuation in any human being, Counselor. What I can tell you is that on the day I examined him, 11 days before he signed this addendum, he demonstrated full cognitive capacity, and he asked me, unprompted, to make sure that was on the record. Cole tried a different angle. Isn't it convenient, Doctor, that a man supposedly worried about being questioned just happened to request this exact documentation at this exact time? Grace was on her feet immediately. Objection, Your Honor. Argumentative, and it's asking the witness to speculate about my client's father's motivations rather than testify to facts. Sustained, Judge Reyes said. Rephrase or move on, Mr. Cole. Cole moved on, but the damage to his theory was already done. The room had felt the shift. A dying man who planned his own defense wasn't a confused man. He was a determined one. Part 9. The confession. The most unexpected moment of the hearing came not from an attorney, but from Marcus himself. Grace called him to the stand under cross-examination, walking him carefully through the timeline of the lockout, the changed keycards, the frozen accounts, the emergency petition filed before the will had even cleared probate. Mr. Whitfield, why did you move so quickly to secure sole control, just 9 days after your father's funeral? Marcus's composure, which had held through most of the hearing, began to crack under the weight of the question, repeated 3 different ways, 3 different times. Because I was afraid, he finally said, quieter than anyone expected. Grace paused. Afraid of what? Marcus looked at Daniel for the first time in weeks, not with hostility, but something rawer. Afraid that if I didn't move fast, I'd lose everything I thought I'd earned. I spent 15 years building relationships, learning the business side, taking the calls Dad didn't want to take, closing deals he didn't have the patience for anymore. And I watched Daniel get the workshop, the floor staff who loved him, the version of Dad that laughed easily. I got the version of Dad who talked about margins. I told myself that meant I'd earned the right to run things when he was gone. I was wrong to lock him out. I know that now. But I wasn't wrong to be scared that everything I built my whole identity around could just disappear. The courtroom was silent. Even Preston Cole didn't immediately object. Judge Reyes let the moment breathe before speaking. Mr. Whitfield, fear doesn't excuse the timeline of your actions, but I'll note for the record that this is the first honest answer this court has heard from either party today. Daniel, watching his brother's hands tremble slightly on the witness stand, felt something complicated move through his chest. Not forgiveness, exactly, not yet, but the first crack in years of quiet resentment. Part 10. The verdict. Closing arguments stretched into the late afternoon. Preston Cole made one final attempt, arguing that even if the addendum was valid, forfeiting 50% of a company built over 3 decades was a disproportionate consequence for what he called an understandable business decision made under grief. Grace's closing was shorter, and it was the line that would end up quoted in 3 different local news write-ups the following week. Robert Whitfield didn't write a punishment, Your Honor. He wrote a promise to his younger son that fairness wouldn't depend on who moved fastest after his death. Grief doesn't excuse taking what wasn't yours to take, and a father's last wish deserves better than being treated as an inconvenience. Judge Reyes recessed for 90 minutes. When she returned, the courtroom had gone completely still. This court finds the addendum dated March 28th to be valid, properly executed, and reflective of Robert Whitfield's sound testamentary intent at the time of signing. Daniel felt his mother's grip tighten on his arm. Beside him, Grace didn't move, didn't smile. She'd told him earlier that a good lawyer never celebrates before the last sentence is spoken. The medical evidence presented today establishes clearly that Mr. Whitfield retained full cognitive capacity in his final weeks, and the testimony of Walter Higgins, combined with the notarization on record, satisfies this court that the document was executed exactly as the deceased intended. Across the aisle, Preston Cole had gone very still, the way attorneys do when they already know which way a case is about to break. Judge Reyes turned toward Marcus. The court further finds that Marcus Whitfield's actions specifically, revoking his brother's access to company systems and filing for unilateral control 9 days after his father's death, prior to any formal distribution, constitute exactly the conduct this addendum was designed to address. Marcus closed his eyes. His hand found the edge of the table and stayed there, like a man steadying himself against something only he could feel. Under the terms of the addendum, Marcus Whitfield's 50% ownership stake in Whitfield and Sons Furniture Company is forfeited in full and shall transfer to Daniel Whitfield, effective immediately. A quiet gasp moved through the gallery. Eleanor Whitfield reached over and gripped her younger son's hand. Daniel didn't feel triumphant. He felt his father's absence more sharply than he had in weeks, wishing for one impossible second that Robert could have been there to see it land exactly the way he'd planned it. But Judge Reyes wasn't finished. However, she looked directly at Daniel now. This court also recognizes that the intent behind this document was never punishment for its own sake. It was the preservation of fairness within a family. I would strongly encourage both parties outside this courtroom to consider what their father actually wanted. Not a winner and a loser, but 2 sons who could carry his work forward together, in whatever form they choose to build that. This court's ruling determines legal ownership. It does not determine what you do with it. She struck the gavel once. Court is adjourned. Part 11. What remains? Outside the courthouse, the late afternoon sun cut low across the marble steps. Marcus stood apart from his attorney, staring out at the parking lot like a man who'd just watched 15 years of certainty collapse in 90 minutes. Daniel found him there. Neither of them spoke for a long moment. "You could have just talked to me," Daniel finally said. "Before any of this. We could have figured it out like 2 adults whose father just died." "I know," Marcus said. His voice had none of its courtroom polish left. "I kept telling myself I was protecting the company. But I think I was protecting the story I told myself about who I was. the one who mattered more, and I didn't want to find out that wasn't true. Daniel looked at his brother for a long moment, really looked at him, past the cufflinks and the composed posture, to the exhausted, frightened man underneath. Dad didn't write that clause because he loved me more, Daniel said quietly. He wrote it because he knew exactly how scared you'd get, and he wanted to give you one more chance to choose different. You just didn't take it. Marcus's eyes glistened, and for the first time since the funeral, he didn't try to hide it. So, what happens now? He asked. Legally, it's yours. All of it. Daniel was quiet for a moment, looking back at the courthouse doors, thinking about a workshop that smelled like sawdust and a father who spent his last weeks building one final piece of furniture, not out of wood, but out of words, joints fitted so precisely that no one could pull it apart after he was gone. Legally, yes, Daniel finally said. But Dad didn't build that company so one of us could win. He built it so it would still be standing long after both of us are gone. I'm not doing this without you, Marcus. But you don't get to walk back in and run it like nothing happened. You start over. Same floor everyone else starts on. You earn it back, the way you always said you wanted to. Marcus let out a breath that sounded like it had been trapped in his chest for weeks. That's more than I gave you. I know, Daniel said. That's the point. Epilogue. 6 months later, the sign above the factory on Route 42 still read, Whitfield and Sons, exactly as it had for 30 years. Except now, if you walked through the floor on a Tuesday morning, you'd find Marcus Whitfield in a work apron, learning to run a lathe from a foreman who'd been there since 1994, sawdust on his expensive shoes for the first time in his life. Eleanor Whitfield visits the workshop every Sunday. She doesn't always remember what year it is or what she had for breakfast, but she always remembers the sound of the machines and the sight of both her sons standing at the same workbench, and she always smiles the same way she did the day her husband first showed her the one-room garage where all of this began. On the wall of the front office, framed beside a photograph of Robert Whitfield at his very first workbench, hangs a single typed page, yellowed slightly with age, the addendum that once tore a family apart, and somehow, in the end, was the very thing that put it back together. Robert Whitfield never got to see how his final act of love played out in a courtroom he never entered. But he'd built furniture his whole life on one simple principle. A joint only holds if both pieces are cut true. He couldn't make his sons fit together perfectly. All he could do was build the clause that gave them one more chance to try and trust that the rest was theirs to finish. On slow afternoons, if you ask the foreman who's worked the floor since 1994, he'll tell you the real proof isn't the framed page on the office wall. It's the sound, most Tuesdays around 4 o'clock, of two brothers arguing over a dovetail joint the same way their father used to argue with himself, and neither one, for once, in a hurry to be right.